The moment I walked through those front doors, the entire room went silent. Not the polite, curious silence of guests noticing a late arrival. This was the sharp, electric silence of people realizing that something was about to go catastrophically wrong. Every head turned. Every champagne flute froze somewhere between the table and someone's lips. The string quartet in the corner stumbled through half a measure before the violinist simply stopped playing altogether. My husband was standing at the center of the restaurant, surrounded by his investors, his mother, and the woman he had been sleeping with for the past 11 months. He was mid-laugh when he saw me, that deep, performative laugh he reserved exclusively for people he was trying to impress. The sound died in his throat. The color drained from his face so quickly it was almost medically impressive. His girlfriend, Renata, was standing 2 feet to his left, in a floor-length ivory gown that I recognized immediately. It was the same designer brand I had personally purchased for an auction gala 2 years ago. My credit card, my receipt, still saved in my email. I smoothed the front of my blazer, adjusted the leather portfolio under my arm, and walked directly toward the center of the room. "What are you doing here?" my husband said, his voice dropping to a controlled, furious hiss. He stepped toward me, positioning his body between me and his guests. "I told you this was a private event. You are not on the list." I looked at him for a long moment without saying a word. "You invested in this restaurant?" I said calmly. "I just came to see what my money built." He grabbed my arm above the elbow and squeezed. Not hard enough to hurt, but hard enough to make a point. The old version of me would have flinched. The old version of me would have apologized for being there. "You need to leave," he said through a clenched smile. "Right now, you are embarrassing yourself." I looked down at his hand on my arm. Then I looked up at him. "You should let go of me," I said quietly, "because the 2 gentlemen who just walked in behind me are from the county civil court. And if you put hands on me in front of them, this evening is going to get significantly more complicated for you." He released my arm like it had burned him. He turned, and his face went slack. 2 process servers in dark jackets were standing just inside the entrance, holding sealed envelopes and a document binder 3 inches thick. That was the night everything my husband had built on top of my money finally came apart, and I was there to watch every single piece of it fall. Let me go back to the beginning, because none of this made sense without context. I was 29 when I married my husband. He was 36, charming in the specific way that men are charming when they have decided you are useful to them. He had a culinary degree, 15 years of kitchen experience, and a dream of opening his own fine dining restaurant in downtown Nashville. He talked about it the way other people talk about religion, with total conviction, burning certainty, and an absolute refusal to examine the practical logistics. I was a commercial real estate analyst at a mid-sized investment firm. I understood numbers. I understood risk. I understood what it meant to put $500,000 into a venture with no guaranteed return and a first-year failure rate hovering somewhere above 60%. I told him all of this. He told me I was being unsupportive. I loved him. That was the part that mattered, and the part that cost me the most. I loved him, and love has a way of convincing intelligent people to set aside what they know in favor of what they want to believe. So I liquidated a portion of my investment portfolio. I pulled from the trust account my grandmother had left me. I structured a formal commercial lending agreement through my firm's private holdings division, with my husband listed as the primary debtor and my holding company listed as the secured creditor. He signed it without reading it. He signed everything I put in front of him without reading it, because in his mind, the paperwork was a formality. We were married. What was mine was his. The contract was just something the lawyers required. He was wrong about that. But I would not find out exactly how wrong until much later. We spent 8 months building the restaurant together. I sourced the location, a gorgeous converted warehouse space in the Gulch neighborhood, the kind of high-ceilinged, exposed brick property that food critics describe as atmospheric. I negotiated the commercial lease directly with the property management company, because that was my job and I was very good at my job. I oversaw the contractor bids, the kitchen equipment financing, and the front-of-house design. I stayed up until 2 in the morning reviewing vendor contracts while my husband attended industry networking events that I would later discover were dinner dates with his sous chef. Her name was Renata. She was 24, had never worked a full dinner service in a professional kitchen in her life, and had been hired 6 weeks before opening because my husband told me she came highly recommended. I found out about the affair 4 months before the restaurant opened when I noticed a hotel charge on our joint credit card for a property 40 minutes outside of Nashville. My husband had told me he was attending a food and beverage conference in Memphis that weekend. The hotel charged for 2 guests. I did not cry. I did not confront him. I sat in my home office for 3 hours, very quietly, and made a series of phone calls. The first was to my attorney. The second was to the managing director of the commercial property firm that owned the Gulch warehouse. The third was to my financial advisor. By midnight, I had a very clear picture of exactly where I stood legally, financially, and professionally. I spent the next 4 months behaving as though I knew absolutely nothing. I attended every planning meeting. I approved the final menu selections. I smiled warmly at Renata when my husband brought her to the soft opening rehearsal dinner and introduced her as the creative force behind the kitchen vision. She shook my hand with both of hers and told me I must be so proud of him. I told her the feeling was mutual. My mother-in-law was at that rehearsal dinner too. She had never particularly liked me. I was too career-focused, she told my husband privately. And not privately enough. Too independent, not warm enough. Not the right kind of woman for a man who needed a partner who understood the sacrifices involved in building something from the ground up. She said this while living in the 4-bedroom house my down payment had helped purchase and eating at the kitchen table I had personally selected and paid for. At the rehearsal dinner, she pulled me aside near the bar and told me, with genuine warmth, that she hoped once the restaurant opened I would consider stepping back from the day-to-day decision-making. "You have your own career," she said, patting my hand. "Let him have this. Let this be his." I smiled and told her that sounded reasonable. I had already met with the property management director 3 weeks earlier. I had already signed the amended agreement. I had already done the one thing that my husband's total faith in his own inevitability had prevented him from ever thinking to check. The grand opening was on a Thursday evening in October. My husband sent the formal invitations 6 weeks in advance. There were 200 guests on the list: food critics, local media, his culinary industry contacts, several potential investors for a second location he was already planning, and his entire family. His mother had a table near the front. Renata had been given a co-host designation on the printed program. I was not on the list. When I asked my husband about it, he told me the seating was finalized and the event was already at capacity. He said it gently, almost apologetically. In the specific tone he used when delivering bad news, he had already decided he was not going to change. He said the event was really for industry people, and that he would make it up to me with a private dinner the following week. "You understand, right?" he said. "It's business." I told him I understood completely. That same afternoon, I called my attorney and confirmed that everything was in order. 2 days before the opening, my husband called me from the restaurant. There had been a last-minute issue with the liquor liability insurance, a coverage gap that the vendor had flagged at the 11th hour. He needed an emergency wire transfer of $22,000 to close the gap before the health department's final inspection the next morning. Without the inspection sign-off, the opening could not proceed. "I wouldn't ask if I had another option," he said. I wired the money within the hour. The inspection passed. The opening was on. I arrived at 8:15 in the evening, after the initial cocktail hour had concluded, and the first dinner seating was well underway. The 2 process servers positioned themselves near the hostess stand as I had instructed. They did not approach anyone. They simply waited. The room was everything I had envisioned when I had negotiated the lease 2 years earlier. The warm Edison lighting I had specified. The custom walnut millwork I had sourced from a reclaimed lumber supplier in Vermont. The open kitchen design I had pushed for against my husband's initial preference for a closed service line. Every single detail that made this space beautiful had at some point come from my vision, my contacts, or my checkbook. My husband recovered from his initial shock with impressive speed. He straightened his jacket and turned to his table of investors with an easy laugh. "My wife," he said, with the particular cadence of a man who is about to publicly reframe reality. "She's been so passionate about this project. I think she just couldn't stay away." There was polite laughter. Renata, to her credit, did not laugh. She was watching me with the careful eyes of someone who had just realized they may have significantly misjudged the situation. My mother-in-law rose from her table near the window. She was wearing a deep burgundy dress and the pearl earrings I had given her for her 60th birthday. She crossed the room toward me with the deliberate pace of a woman who believed she was about to de-escalate something. "Sweetheart," she said, taking both my hands. "What are you doing here? You know tonight isn't." "I know exactly what tonight is," I said. I squeezed her hands gently and let them go. "I'll explain everything in a few minutes." I walked to the center of the room, set my leather portfolio on the nearest empty table, and opened it. The room had not returned to normal conversation. People were watching. The investors at my husband's table had stopped eating. One of them, a woman in a gray blazer, whose restaurant group operated 11 locations across Tennessee and Georgia, had put down her fork entirely and was watching me with the focused attention of someone who had been in enough business meetings to recognize when the actual meeting was starting. I withdrew the first document from the portfolio. It was a 43-page filing. "Marcus," I said. I used his name deliberately. Not Honey, not my husband, his name. "I need to tell you something in front of these people, because I want there to be absolutely no confusion afterward about what happened here tonight." "This is not the time," he said. His voice had dropped into the register he used when he was genuinely angry, lower, slower, stripped of its social polish. "I think it is," I said. "You opened a restaurant tonight, a restaurant I financed. A restaurant whose opening you deliberately excluded me from because you are planning to divorce me, and you believed that the moment this business became profitable, you could repay the commercial note through the restaurant's revenue and dissolve our financial partnership before I had time to respond." The room was completely, utterly silent. Marcus's jaw tightened. "That is an insane. Your attorney sent mine a preliminary divorce filing 3 weeks ago," I said. I chose not to respond to it until tonight because I wanted to wait until I was standing in this room. I handed the first document to the process server on my left, who walked it calmly to Marcus and placed it in his hand. "That is a formal demand for repayment of the commercial note," I said. $540,000, including the accrued interest specified in the original lending agreement. The note is now in default because you missed the first scheduled payment that was due on the 1st of this month. You had 90 days after the restaurant's opening to make that first payment. You opened tonight. The payment was due 17 days ago. You did not make it." Marcus was staring at the document. I could see his eyes moving rapidly across the page. "I've been paying startup costs," he said, his voice rising slightly. "You know the payment timeline is—" "The payment timeline is what you signed," I said. "I did not modify it. You did not request a modification. The note is in default." I withdrew the second document. "That is a writ of attachment," I said, "issued by the Davidson County Civil Court 2 days ago. It authorizes the immediate attachment of the business assets of this establishment as collateral against the defaulted commercial note." One of the male investors at Marcus's table pushed back his chair and stood up. He was older, silver-haired, the kind of man whose entire body language communicated that he had not survived 30 years in the restaurant industry by sitting still when paperwork started appearing. "What exactly is being attached?" he asked. "The kitchen equipment," I said. "The furniture, the wine inventory, the point-of-sale systems. All of it was purchased with funds from the commercial note, which makes it secured collateral under the original lending agreement." The second process server set a copy of the attachment order on the investor's table. Marcus finally looked up from the documents. His face had moved past shock into something rawer and more frightening, the specific expression of a man who has just understood that he is not going to be able to charm his way out of this. "You cannot do this," he said. "This is my business. We are still married." "We are still married," I agreed. "Which is why your attorney should have thought more carefully before sending that preliminary divorce filing before the restaurant opened. The moment that filing was recorded, your intent to dissolve our financial partnership became a matter of legal record. It triggered the default clause in the commercial note. Section 7, paragraph 3. I highlighted it for you." Renata made a small sound from across the room. It was not quite a word. It was the sound of someone doing very fast arithmetic and arriving at a number they did not like. My mother-in-law had gone completely still near the edge of the room. The burgundy dress, the pearl earrings, The careful social composure, all of it had drained away, leaving something older and more frightened underneath. "You are destroying his career," she said. Her voice came out thin and high. "In front of everyone. You are doing this deliberately. In front of his investors, in front of the press. You vindictive." "I invested $540,000 into this restaurant," I said, turning to face her. I kept my voice level. I had rehearsed this moment many times, and in every version, I stayed level. I sourced the location. I negotiated the lease. I oversaw every vendor contract and every equipment purchase. I wired $22,000 to save the liquor license inspection 2 days ago after your son called me from this restaurant asking for help, and I was not invited to the opening. She opened her mouth. "I'm not finished," I said quietly. She closed her mouth. "I have been a good financial partner to your son for 3 years. I have been a good wife. And while I was reviewing vendor contracts and structuring financing agreements, your son was conducting an 11-month affair with a 24-year-old he hired with my money. So I want you to think very carefully before you use the word vindictive to describe what I'm doing tonight." The woman in the gray blazer at the investors' table leaned over to the man beside her and said something in a low voice. He nodded slowly. Marcus threw the documents onto the table. "The lease," he said, his voice cracking. "Even if you attach the equipment, I have the lease. I have a 3-year commercial lease on this building. I have a business address. I have a location. I can restock the kitchen. You can take the furniture, but you cannot take my location." Several of the guests near the hostess stand exchanged glances. A few of the local food media people had their phones out. Not obviously, not aggressively, just angled in a way that suggested the record function was quietly running. I reached into the portfolio one final time. I had waited for this specific moment. I had thought about it while negotiating the lease. I had thought about it while my husband signed every document I placed in front of him without reading the managing agent line at the bottom of each page. "You're right that you have a commercial lease," I said. "You signed it with a property management company called Covenant Commercial Holdings." "That's right," he said. The smallest flicker of relief crossed his face. "And they have nothing to do with." "Covenant Commercial Holdings is a subsidiary of Meridian Property Group," I said. "Meridian Property Group is the commercial real estate portfolio that I manage professionally. I have managed it for 4 years. I recommended this specific property to you. I negotiated this specific lease. I know every clause in it by memory because I wrote the standard template it was based on." I set the final document on the table between us. "I am your landlord, Marcus," I said. "I own the building you are standing in." The room did not gasp. It went something beyond gasping into a kind of suspended collective breath where every person present was simultaneously processing the same information and arriving at the same conclusion. Marcus stared at the document. He stared at it for a long time. "That's not possible," he said finally. "You never told me. You never asked," I said. "You signed the lease the same way you signed the commercial note, without reading it, because you trusted that everything I put in front of you was in your interest." I paused. "That was a reasonable trust to have in a partner. I just turned out to be a much more thorough partner than you anticipated." I gave him the full weight of the next silence before I continued. "Your lease contains a standard covenant commercial clause regarding financial misconduct on the premises. When you structured a secondary equipment financing agreement using forged documentation to list this address as collateral without my knowledge or consent as the property owner, you placed this building in legal jeopardy. That constitutes material breach. Effective as of this morning, your commercial lease is terminated." Renata stood up from her chair. She had been very still for the past several minutes, but now she stood up with the fast, purposeful movement of someone who has just made a decision. "Renata," Marcus said, turning toward her. "Don't," she said. "We talked about this. Whatever happens tonight, we are in this together. We have a plan." "I don't have a plan with you," she said. Her voice was entirely flat. "I have a job. I'm an employee of this restaurant. And if the restaurant is closing, I need to go call my agency." "You told me you were ready to build something with me," Marcus said. His voice had dropped into something unguarded and genuinely bewildered. He sounded, for the first time all evening, like a man rather than a performance. "You told me that once the divorce was finalized, I told you a lot of things when you were the primary investor in a restaurant I was being offered a head chef position at, Renata said. She picked up her clutch from the table without looking at him. That's not the situation anymore. We talked about the future, he said. We talked about Marcus. She finally looked at him directly. I'm 24. I'm not starting my career over because you forgot to read a lease agreement. She walked to the coat check without looking back. Marcus stood very still in the center of his restaurant, surrounded by the best investors his charm had convinced, the food critics his vision had attracted, and the furniture his wife's money had purchased. His mother was crying quietly near the window. The string quartet had not resumed playing. The woman in the gray blazer stood up, buttoned her jacket, and picked up her bag. She looked at me briefly with an expression that contained something I did not fully expect. Not sympathy, exactly, but a kind of recognition. She gave me a single, small nod and walked toward the exit. Her colleagues followed. The other investors at the table gathered their coats with the efficient, expressionless speed of people who had seen enough. Marcus watched the last of them file out through the front doors. He stood in the center of the room and watched his opening night empty out like water from a broken glass. 6 weeks later, I was sitting across from my attorney in the wood-paneled conference room of the Davidson County Family Court building when my husband's attorney made his opening argument. He was a competent lawyer. He had a good voice and good posture, and a genuine talent for making catastrophically bad situations sound like minor misunderstandings. He told the judge that his client had operated in good faith. He told the judge that the commercial note had been structured in an unusually punitive manner. He told the judge that the termination of the commercial lease had been retaliatory and financially devastating, and he asked the court to award his client damages commensurate with the projected revenue loss of a restaurant that had been, in his exact words, destroyed at the moment of its greatest potential. He asked for $800,000 in damages. He asked for the court to void the attachment order. He asked for a finding that the commercial lease termination was unlawful. My attorney let him finish. She let the full silence of the courtroom land before she stood up. She pulled 3 documents from her binder and handed copies to the judge. The first was a forensic accounting report, prepared by a certified fraud examiner, documenting 31 separate instances over the past 14 months in which funds from our joint accounts had been transferred to cover personal expenditures for Renata, including rent on a midtown apartment, travel costs, clothing purchases, and a car lease. Total diversion, $87,000. The second was a sworn affidavit from the equipment financing company's compliance officer, confirming that the secondary financing application submitted under this restaurant's address had included forged documentation representing co-ownership of the property. The third was a copy of the preliminary divorce filing. Marcus's attorney had recorded 3 weeks before the restaurant opened the filing that had never been formally served to me, that had simply been quietly entered into the court system in preparation for a divorce Marcus had been planning while asking me to wire emergency funds for his liquor license inspection. My attorney placed all 3 documents in front of the judge and clasped her hands. "Your Honor," she said, "my client structured and financed this restaurant under a legally executed commercial lending agreement that her husband signed. The agreement was fair, clearly worded, and structured to protect both parties. My client enforced it. There is nothing punitive about the enforcement of a signed contract. Furthermore, the fraudulent documentation used to secure secondary financing on property my client owns as landlord created a direct and documented liability. The lease termination was not retaliatory. It was legally obligated." The judge read through the forensic accounting report for a long moment. "Counselor," she said to my husband's attorney, "your client is seeking damages for losses resulting from a default that was triggered, in part, by a divorce filing he himself initiated. Is that an accurate summary of the situation?" There was a pause. "It is somewhat more nuanced than," his attorney began. "It is a yes or no question," the judge said. Another pause. "Yes, Your Honor." The judge set the report down and looked at Marcus directly. "Sir," she said, "you borrowed money from your wife. You signed a contract with a default clause. You initiated divorce proceedings before your first payment was due, which triggered that clause. You then sought emergency funding from your wife 2 days before your opening and she provided it. And now you are asking this court to award you damages because she enforced the contract you signed. Marcus said nothing. Your request for damages is denied, the judge said flatly. The attachment order stands. The lease termination is upheld. The outstanding balance of the commercial note, $540,000 plus accrued interest, is owed to the plaintiff's holding company in full. Given the documented diversion of marital funds and the fraudulent financing documentation, I am granting the plaintiff's request for an asset judgment. Any income your client earns as a licensed culinary professional will be subject to wage garnishment until this debt is satisfied. We are adjourned. The gavel came down. I sat still for a moment in the quiet after it landed, feeling the particular sensation of something very heavy finally being set down. 8 months after that courtroom, I was standing in the Gulch warehouse on a Tuesday morning in June, when the last of the renovation crew packed up their equipment and carried their toolboxes out the front door. The space looked nothing like it had on the night of the opening. The performative open kitchen my husband had insisted on was gone, replaced by a proper professional service setup with actual functional flow. The moody, low lighting had been redesigned by a Nashville-based lighting consultant, warmer, layered, less focused on dramatic effect and more focused on making people feel comfortable enough to stay for 3 hours and come back next week. The new tenant was a woman named Dara, 41 years old, a James Beard-nominated chef who had spent 15 years working other people's restaurants in New York and Chicago and had relocated to Nashville 2 years ago, specifically looking for a space like this one. We had met at a commercial property tour I hosted for new business tenants in the Gulch corridor. She had walked through the warehouse with the careful, unhurried attention of someone who was building something she intended to keep. I liked her immediately. We structured a 10-year lease with a revenue-sharing option at year 5, with a first right of refusal if she ever chose to buy the building outright. Her restaurant opened on a Thursday in June. I was on the guest list. I sat at a corner table near the window and ate the best meal I had eaten in 3 years, a slow-roasted lamb with a pomegranate reduction that tasted like someone had thought very carefully about what joy was supposed to feel. And I watched Dara move through her dining room with the easy confidence of a person doing exactly the work they were built for. The garnishment notification came through on my phone at 9:45, right as they brought out dessert. An automatic transfer. On time? For the first time? I silenced my phone and put it back in my pocket. My attorney had warned me that the garnishment process would be slow and inconsistent at first, that it often required follow-up enforcement actions before the schedule normalized. She had been right about that. The first 3 months had involved 2 separate compliance hearings, but the 4th month had been on time, so had the 5th. It would continue for a long time. Long enough that my husband would feel the weight of every payment for years, not because I wanted him to suffer, but because suffering the consequences of what you sign is simply how adult agreements work, and I had learned that lesson so that he eventually would too. Dara stopped by my table on her way back to the kitchen. "How was everything?" she asked. "Extraordinary," I said, and I meant it in more ways than one. She smiled, genuinely, the unguarded smile of someone who has earned the right to be proud of what they made. She thanked me and headed back through the kitchen doors. I finished my dessert. I left a 30% tip for the server. I walked out into the warm Nashville evening and stood on the sidewalk for a moment, listening to the sound of the street. There is a version of this story I could tell that is about betrayal, about the specific ache of discovering that the person you trusted most viewed your love as a resource to be managed rather than a partnership to be honored. That version is true. I lived inside it for a long time. But the version I want you to walk away with is this one. I was a 29-year-old woman who invested everything she had, her money, her expertise, her contacts, her 18-month renovation calendar, and her whole heart into a dream that turned out not to belong to her. And instead of collapsing when that became clear, I went back to the contracts. I went back to the agreements. I went back to the documents that nobody had read carefully enough, and I found, in the fine print, exactly what I needed. The lesson is not to trust no one. The lesson is not to keep your heart in a safe deposit box and your feelings in a spreadsheet. The lesson is that love and legal literacy are not opposites. They never were. Protecting yourself financially does not mean you love someone less. It means you respect the partnership enough to formalize what it means for both of you, and it means that if the partnership ever ends, Neither person can walk away pretending the terms were something other than what they were. My grandmother left me a trust account, 2 pieces of advice, and a handwritten card I still carry in my wallet. The card says, "Know what you are signing, know what you own. Never let anyone convince you those things are unromantic." She was married for 51 years. She knew what she was talking about. I walk into that Gulch building twice a month now for property management check-ins. Sometimes I stop and stand in the middle of the main floor for a moment, just listening. The sound of a full restaurant is a specific thing. It is plates and conversation and the low ambient warmth of people choosing to be somewhere. It is a living sound. It means the place is working. I built this space with my own money, my own knowledge, and my own stubborn refusal to accept that my contribution did not count. And every single time I hear it, that full, warm, working sound, I think about the night I walked through the front door of a party I was not invited to, and reminded a room full of people exactly whose name was on the building. I thought about my grandmother's card. I thought about what it feels like to know what you own. It feels like that sound. It feels exactly like that. If any part of this story felt familiar, if you have ever sat across from someone you loved and felt your contribution slowly being erased, I want you to know that the paperwork is still there. The receipts are still there. The agreements you made in good faith are still legally yours to enforce, no matter how many times someone calls you difficult for remembering them. Know what you signed, know what you own, and never, under any circumstances, let anyone tell you that knowing those things makes you something other than a woman who loves intelligently. Take care of yourself. I'll see you in the next one.